Okay, so it's 12 o'clock now, so we're going to go ahead and get started. So thank you everyone for joining us today on what I've called the probate prevention. Over the next half hour or so, we're going to discuss all things probate, how sellers can prevent having to go through the probate process in order to sell those particular properties, because it can be a stressful and long process depending on how you get it done. And so to help with this, I have attorney Shawn Head with us. He is the founder and managing member of the Head Law Firm, PLC. He's been named as one of Metro Detroit's top lawyers for several different years by D Business Magazine. He's also been selected as a top attorney by Michigan Super Lawyers in 2023 and 2024, and a rising star by Michigan Super Lawyers for several years. And with the top attorney by Michigan Super Lawyers, that is a recognition limited to the top 5% of attorneys in the state. And Shawn is a member of the State Bar of Michigan, Illinois, Livonia, and the Michigan Association of OWI attorneys. So thank you, Shawn, for joining us today for the probate prevention.
Very much for having me.
You're welcome. So with the first basic question for people who don't know, what is probate?
So probate is, there's a particular court that handles, every county has a probate court, and probate courts handle decedent estates. So when somebody passes away, they handle the estate for the deceased person. They handle conservatorships, guardianships, minor adoptions. Also, potentially there's some types of trusts are supervised, and the probate courts handles those types of cases as well. So anything related to decedent estates, guardianships, conservatorships, those are all handled within the probate courts.
Okay. And you kind of already talked about the different types of probate. So I guess, can you elaborate more on if someone doesn't know what a conservatorship is, guardianship, and all that?
Sure. So every state's different, but in Michigan, we have guardianships and conservatorships. Guardianships, a guardian deals with where the individual who needs a guardian is living, deals with their care, provides for their shelter, their food, those types of things, their care, their medical care. Whereas conservatorships deal with protecting assets, protecting money, managing money, those types of things for somebody who can no longer do or handle those types of things themselves, either because of the fact that they're a minor, or because maybe they have some disability, or they have some mental illness, or maybe they're just elderly and they need some help in navigating how to pay bills online or manage their care, things of that nature. So oftentimes, if somebody needs a guardian and they have assets that are in need of some protection, be it real estate holdings, a significant amount of income, business interests, things like that, then they might not just need a guardian that can manage their care and their health care and where they live, but they might also need a conservator to help manage their finances and protect their assets. So oftentimes they're the same person, but they don't need to be. Somebody could have a guardian that's one relative or a close friend or somebody they designate, and they could have a totally different person handling the conservatorship, managing and protecting their assets. So those are the differences between guardianships and conservatorships in Michigan. Also, decedent estates, that's when somebody passes away, or if a relative passes away, and their assets need to be handled within the probate court or supervised by the probate court, then that's where a decedent estate and there would be a personal representative who is appointed what Michigan calls the executor of a decedent estate. And that personal representative then would basically step into the shoes of the deceased person and be able to manage all of their assets, whatever that was in their name only at the time of their death, whether that's real estate or business interests or financial accounts, bank accounts, investment accounts, all those things that were in their name only at the time of their death. The personal representative would have to administer and distribute those assets.
And what is the process of selling a home through probate? What is the process of selling a home through probate?
Okay, well, so it could take many forms, and the first thing I guess the first variable would be what type of probate. So if we're talking about a deceased family member, so let's say dad owns a home and dad passes away and the house was in his name only at the time of his death. Well, then we'd have to open up an estate in order to have somebody appointed as the personal representative who would then have the authority to sell that property on behalf of the decedent estate. So there's a couple different ways to open a probate estate to handle that type of a transaction. And a lot of it depends on, well, first of all, we got to see whether there was a will or not. If there was a will, then that will likely nominate who's going to serve as the personal representative, who that person wanted to be their personal representative for their estate. That individual who's nominated in the will have super priority to be appointed. So that means there's a couple different ways that they can open the estate. They can open it without a hearing by filing a application for probate in the county where the person lived when he passed. And that application, because that person has priority to be appointed personal representative, that application can be granted without a hearing, and somebody can be appointed personal representative without a hearing. That's a much faster process. So it's important for somebody to have a will and nominate who they want to serve as their personal representative. It helps to speed up that process. Other people can have priority without a will. Let's say somebody passed away and they need to sell a piece of real estate that's in their name only, but they only have one child. They don't have a spouse, but they have one child. Well, that one child is going to have priority because that's the next of kin to be appointed the personal representative. If somebody has a spouse and they don't have a will, the surviving spouse usually has priority to be appointed as the personal representative. There's another way to open up a probate estate, and that is by petition. Sometimes you can't use the shortened process by application and get a personal representative appointed. Sometimes you need to go file a petition with the probate court, and then you have to have a hearing. And the reasons for that would be maybe there's equal individuals who have priority to be appointed. So for example, somebody passes away and they leave more than one child, no surviving spouse, but they have multiple children. All those children are going to have equal right to be appointed. Maybe they don't all get along. So you have to file a petition, nominate somebody in that petition to serve as the personal representative, and then have the probate court decide who is the appropriate choice to be appointed. Sometimes there's competing petitions. Unfortunately, we see it often that when somebody passes away, sometimes, especially if they don't have their affairs in order clearly, then sometimes some family members will unfortunately fight and get into some disputes over who's entitled to what, who should have control, things of that nature. So I guess to get back to your question, there's a few different ways to open and start the probate process depending on some factors. With respect to a guardianship or a conservatorship, sometimes, let's say somebody, an elderly person, for example, owns a piece of real estate and they have dementia and they've lost their ability to make their own decisions or enter into a contract, for example, to sell real estate. So if that's the case, then hopefully they've nominated somebody to serve as a guardian and conservator if they need one. If they haven't, then a family member, usually, whether it's a surviving spouse or a child or somebody interested in that person's affairs and care and estate, can petition the court to be the conservator. And in this case, because we're talking about somebody's assets, a conservator would have to be appointed in order to sell a piece of real estate for somebody that doesn't have capacity to do it themselves because of a disability, or they're in a coma, or they've got dementia, something like that. So that process is started by somebody filing a petition with the probate court, nominating somebody to serve as the conservator, and then there has to be a hearing. The court will also appoint what they call a guardian ad litem, GAL. And that's somebody that's appointed in guardianship and conservatorship proceedings, basically be an investigator for the court, kind of like the court's eyes and ears. And that individual will go out and meet with the person who is in need of protection and advise them of their rights, see if they understand the process, see if they have any objections to who is nominated as the conservator, for example, and then let them know that they have an opportunity to attend the hearing or object. And then there will be a hearing in probate court to determine who is a suitable choice to serve as that individual's conservator. Then they get letters of conservatorship, and then they have the power to protect and marshal and the assets of the individual in need of protection, including selling real estate.
Okay.
So,
Yeah, I have follow-up questions on those things, but you're in this questioning, so they'll come as they go. So I guess for the more, and you can say each one too, but ideally the more traditional route that if someone passes away and things are going smoothly, how long does it typically should take to start to end the probate?
sure. So most of the probate estates that we handle, we can open by application. So that's the shortened process without having a hearing, without having to file a formal petition and then have a hearing and go before the judge to be decided. So if we apply by application to have a personal representative appointed, it varies a little bit by county, but you should be able to get letters of authority the same day or within a couple days from when you file that application. And letters of authority is the document that the probate court issues appointing a personal representative. So you can usually get those letters of authority for an informal probate, meaning you opened it by application without a formal hearing, and unsupervised probate, meaning that there's no need for the court to supervise it. Most decedent estates are unsupervised and they're informal. So once you get a personal representative appointed, that individual most of the time has unrestricted authority, meaning that they can sell real estate right away. So, which is, the topic of most of our conversation here today. So if you had somebody where dad passed away and dad owns the house in his name only, and you can open up a decedent estate by having one of the children, either they all agree and nominate one person, or say the deceased person only has one child. So keep it simple, that person has priority of appointment, then they can get appointed as soon as they file the application with the probate court, and they should get unrestricted letters of authority. So they should be able to sell real estate right away. That they don't have to wait to close the estate or wait to the end of the administration process to sell real estate. They can enter into a purchase agreement as soon as they have the authority to do that. From start opening the estate until the time you can close it, it depends on a few things. You've got to administer all the assets. So when you open an estate, you've got 91 days essentially to figure out what are the assets of the estate, what did the deceased person own in that person's name only, and then how is it to be distributed. If there's a will is basically a roadmap for what should happen to a deceased person's assets in the probate court. So the will would say, how things are divided, and then the personal representative would have the authority to follow the will and would have the requirement to follow the will and distribute assets according to what the will says. You also have to publish notice to creditors. So you have to publish in the Detroit Legal News, for example, or the Oakland County Legal News, or some other publication to put any potential creditors of the deceased person on notice that a decedent estate has been opened, and they have a short window of time to present a claim if they want to try to, say that the estate owes them money. So a credit card, for example, they would have a 4-month period to file a claim against the estate saying there's an unpaid credit card bill that was owned by the decedent, and we want to get paid. If they don't, if creditors do not file a claim within that window, within that 4-month period, then all their claims are barred. So it's important to, when you open the estate, to publish notice to creditors right away, because it opens that 4-month window. And in Michigan, when you open a decedent estate, you can't close it for 5 months or until the creditor window closes, whichever is later. So that's another reason why you want to publish notice to creditors, open that creditor window right near the beginning of the time that you open the estate. Other things that you might need to leave the estate open for would be like filing final tax returns for the decedent. Depending on when they died in the year, you'd have to file that person's final tax return. And depending on whether the estate made money, let's say the estate owns income producing property or some type of a business, or or they sell the piece of real estate for a significant profit, there may be a need to file taxes on behalf of the estate. And any CPA or tax preparation professional should be able to assist the personal representative in doing that. But that may mean that you have to leave the estate open a little bit longer until all tax filings are completed.
So for those scenarios like the tax filings or owing money to creditors, basically, let's say you had a very quick probate process because they had a will and it only took a month or two and they sold the house, then they would just need to leave that money in some kind of escrow, or I guess with however you would handle that, right? Until that timeline is over.
Yeah, that's a good question. So let's say we had a scenario where you're able to open an estate by application. You're able to get letters of authority right away. You're able to sell the property right away because you have unrestricted letters of authority. Then that money, you just got to make sure that you don't distribute it right away. You should open up an account in the name of the estate, and any title company will require that when there's proceeds from the sale of real estate, those proceeds can only go to the estate account. So they'll require that you get an EIN, which is an employee identification number from the IRS, and that the estate has its own bank account. And so all money that's liquidated should be consolidated into that estate bank account. And then from there, that's where the personal representative would pay accountant fees, legal fees, any other costs related to the administration of the estate, and any taxes, tax liability, or pay off any creditors, those types of things. So there should be enough at least reserved so that the personal representative can pay any creditors that need to be paid, pay any costs related to the administration, pay professionals, and do whatever they need to do to administer the estate. So sometimes, depending on the value of the estate, you can make partial distributions because there's no need to leave significantly more money than necessary in there. And partial distributions can be made at any time. So it just depends on what the family's needs are, the size of the estate, things like that.
Okay. So it's kind of going from the initial question earlier. So, a lot of times realtors, they'll list a home for sale saying it's subject to probate court approval, meaning the probate process most likely hasn't been started at all when they should have already either had the attorney start that. So is it true that in certain types of real estate, types of probate or circumstances, the process actually can't begin until a deal is in place, or is it more so just that they just didn't start it when they could have?
That's a very good question, and it depends. So usually, when I was talking earlier, I was talking about unrestricted powers. I was talking about unrestricted letters of authority. There are some situations where the probate court issues restricted letters of authority. Usually, the most common way that happens is when they couldn't open the estate by application, and they had to open the estate in a formal way by petition, meaning they had to file a petition nominating somebody to be appointed personal representative, and then they had to have a hearing, and then the court appointed somebody after that hearing. Often, most times, in that situation, when you open that formally, you will get restricted letters of authority, meaning the personal representative gets appointed, but their letters of authority say that you cannot sell real estate without probate court approval. So that's when you most often see a purchase agreement that says subject to probate court approval. Usually the probate process has already started there, and you just need to have the probate court approve a potential sale for real estate because they had restricted letters of authority. So in that case, it's not a very difficult process to get a proposed sale approved, but you have to actually have a deal in place because or a potential deal in place, because the court form that you file, the petition for approval of real estate, the sale, the petition for approval of sale of real estate, requires you to put in the potential buyer's name, the potential sale price, and you're asking the court to approve a specific deal. So that's where you usually see it in a purchase agreement, where it's subject to probate court approval. Now, the other way it could happen is, let's say that the seller is a family member of the owner who had recently passed. They know that they're going to have to open up probate, but they haven't done it yet. Well, a real estate that encounters that situation, a real estate agent should say, let's open the estate so that you have either letters of authority to enter a purchase agreement and sell right now, or you'll get restricted letters of authority, and we know that, so we'll put that into our purchase agreements and our listing information, so that we know, so that buyers and buyers agents know that. In terms of a timeline, if you have to get probate court approval, it all depends on the county, but it may take up to a month or so from the filing of the petition for approval until you get a hearing date and actually get probate court approval for the sale. So it does add time to the process. So the earlier you can file that petition and get a hearing date scheduled, the better. So even, once you have a purchase agreement signed, file that petition for the approval of sale of real estate right away. That way you can get on the court's calendar and get a hearing date as soon as possible.
Yeah, I had one years ago where the agent said it was through probate, and he thought it was, or whatever.
Mhm.
And then it was bidding war, they accepted our offer, and come to find out immediately it wasn't through probate, and the attorney would not, even though she was going to be the only person that could, as you said, she was the heir, she would be the person that would take it over. He wouldn't allow her to sign the purchase agreement until they went through probate. So it was actually very cumbersome because, we don't know we have an offer accepted because it's not signed. So how it resolved it was that they would pay for the inspection. So, they paid another $500 that they may not have needed to pay if. But was that what you would have done? Would have said you can't sign yet because you're not really the personal representative?
Well, what I've seen is that I've seen this several times. Sometimes there's maybe an inexperienced real estate agent, and they just don't know enough about their client to kind of know what needs to be done. And so I've seen purchase agreements that are signed with a relative of the deceased owner of the house, but they didn't have any letters of authority. They had no authority to enter into that agreement. So what that does is that kind of leaves the seller hanging, and the buyer and the agents, everybody hanging, because that agreement's void. Anybody can just say, oh, I'm not going to go through the sale, or I'm not going to go through with the purchase. And because the individual was not appointed personal representative, that family member didn't have the authority to sell that house or enter into that purchase agreement at all. So I've seen that happen, unfortunately, sometimes near the end of the deal, or close, far enough into the deal where they have title work done, and they realize, oh, we need, an estate needs to be opened, and this purchase agreement is void. We're going to start all over again. That can be especially problematic, as when there's some, either high demand, or there's some competing offers, or there's some contention between what maybe repairs that need to be made to the home, or a lot of back and forth between the buyer and seller. So that can be especially problematic. So I think it's important for real estate agents to know all that they can about their client, about the seller, about who owns the property. I would even suggest taking a look at the most recent deed before, especially if there's any question, just before you enter into any purchase agreement or accept any offer.
Yeah, I think well, that's the thing too, right? Sometimes I wouldn't know if it went through
Right.
probate because it the right way. I'm just listing the property at that point. But I mean, it seems more common than not, they're not doing, something's missing. Like I had one where it was on the market for like a whole 6 months almost. We got the offer accepted. We were literally clear to close, and somewhere in between, the agent stopped talking to me and not answering questions. And come to find, they didn't do the title work until they got the offer accepted. And it did show that this person was on, public record that she was the owner. But what she didn't share, or she didn't understand, or the agent didn't know, was that how they held title. The other people that passed away, their ownership didn't disappear. You still had the other half that she didn't own, and so she had 8 siblings that had to agree on if they were going to do it or not, and it took too long. So it was just a big waste of time.
Yeah, I've seen that. I've seen that before too, especially in if families have deeded the property back and forth between themselves many times without, especially without using a lawyer, without going through a title company, without a traditional type purchase or sale. I've seen that very often. I had a case not too long ago where dad conveyed his property, this cabin up north, to his 5 children as tenants in common, meaning they all had undivided interests with no survivorship provisions. So 50 years later, when one of the daughters went to sell the property because she thought she owned it, she's been paying the taxes, she's been the only one using it for the last 50 years, 40 years. She went to sell the property and realized she had all these siblings owned just as equal shares as she did. Some of them have passed away, some of them had children, some of them did not. That was a mess. We had to clean that up clean up the title and consolidate the title and open up multiple estates, and it was messy to clean up. So it's always best to know all that information before you enter into a purchase agreement.
So, going back to personal representative, I've been told before that anyone can essentially name themselves as the personal representative. So you really shouldn't count that as, oh, I'm good to go to list the property because you have something that says you're the personal representative.
Sure. I just had, for example, I just had a situation recently where an individual passed away, and she had a long-term boyfriend or fiance that had been living with her for the past 20 years, but they were not married, and he was not on the property. He was not on the deed, and there was no will that anybody knew of. So the individual that passed away didn't have any spouse, didn't have any children. So her brother went to sell one of her pieces of real estate, and thought that he had authority to do that because he was her closest relative legally, and didn't. Come to find out, they found a will, and she had nominated her long-term boyfriend to serve as a personal representative. So even though he thought that he was going to be the personal representative, he wasn't, and he didn't have priority. He wasn't nominated, and it was going to be the boyfriend. So he had been talking to a couple of real estate agents and was just about to list this piece of property when I got involved on behalf of the boyfriend, and was able to kind of stop that situation and explain, to the brother, look, with all due respect, you don't have authority to sell the real estate. There was a will. Here's what it says. And, luckily I was able to cut that off. But I've seen situations where, yeah, anybody can say, I'm going to be the personal representative. I'm going to be the one that's in charge of this estate. But until an estate is open and that person has letters of authority, you're right. You can't really trust what they say because anybody can say that they're going to be a personal representative.
Okay. So I think you already talked about what letters of authority are. So next question would be, do some sellers choose to work on the probate process once there's, whatever else you have to say, this can kind of cover it a little bit. Once there's a deal in place because they don't want to pay for an attorney up front, they don't know any better, or you think it's just because their realtor attorney likely hasn't explained how it should be done to avoid potential issues.
Yeah, and it could be any of those things. Sometimes the family says, well, I'm the surviving spouse, even though the property wasn't in my name, I'm not on the deed, I must have authority to sell the property. I'm the next of kin. Everything's going to go to me. And even if that's true, even if the law says that everything would go to that surviving spouse, they still need to do it the right way, open up a decedent estate, get the letters of authority saying that they have the authority to sell a piece of real estate. Because they don't want to find out, shortly before closing when the title company says, you don't have authority to sell. It's in the name of the estate of, John Smith. So sometimes it's because they make assumptions, the family members make assumptions that, they don't need to open an estate, or they don't need an attorney to help them out. They don't need to seek advice of people that know how to do this. They can just kind of wing it, and they find out, unfortunately, that they can't. Sometimes it is because real estate agents, especially when in the situation where you have restricted letters of authority, where you're going to have probate court approval. Sometimes real estate agents don't realize that, or the sellers don't realize that until the end. and they get ready to, again, sell the property, have a closing, and they realize that they need a court order and the title company won't close the deal. So then they've got to file a petition, wait another month or so for a hearing, and it just delays a lot of things, especially if there's strict timelines in the purchase agreement. Maybe you lose your buyer that way. So hopefully not. Hopefully buyers are understanding, but you know, the markets are, you know, they're volatile. You never know what's going to happen.
Yeah, I have a couple right where they don't want to hire an attorney, and one probably should have been pretty easy because there's a will, and it's been about 2 years since she said she was working on it. So
Yeah, it can be frustrating. And you know, reality is they're not going to be able to sell it until they get the probate court to appoint a personal representative. People can do it on their own without an attorney. That is certainly possible. It's not advisable, especially if there's complicated real estate holdings or complicated business holdings or other assets that are complex and need to be administered. But you know, somebody can go on to find the forms, file the proper forms. The probate court can't give advice, so you can kind of ask for how the procedure works, but they can't give legal advice. So it's just a lot smoother for somebody to use an attorney because, you know, we do this every day. And, you know, if somebody that is grieving because they just lost a family member, you know, they've got enough on their plate to deal with than to try to deal with the intricacies of navigating the probate court process and doing all of those things that can be handled by a professional. So.
yeah, so to avoid going through probate altogether, it's often best for people, well, depending on the situation, right? It's often best for people of a certain age to hire a good real estate attorney to set up a trust with the property or properties in it, or set up a ladybird deed. So if they pass away, there's no probate process and ownership is already defined. So if they want to sell the home, they can do so anytime. Is that for the most part correct?
Yeah, I mean, there are some ways to avoid probate if that's what you're saying with respect to real estate. One way to do that is a ladybird deed, like you described, an enhanced life estate deed, and that's where somebody deeds the property. So I'll use myself an example. I deed my house from myself to myself for my lifetime, coupled with the power to change my mind, sell it, mortgage it, rent it out, do whatever I want. But if I do nothing, then upon my death, it goes to my wife or my children. And that would avoid probate altogether. That would ought to be an automatic transfer from the owner to whoever they designate as the individual on the ladybird deed, on the enhanced life estate. So that's one way to avoid probate. Another way would be to deed the property into the name of a trust or do a ladybird deed into the name of a trust. So for example, that's what I actually have done with my primary home. I deeded it. I did a ladybird deed from myself, my wife and I to ourselves for our lifetime. But if nothing happens to us, or if we don't do anything, then we ladybird deeded the property to our trust because we have minor children. So you know, we would want them to be able to get the proceeds and, you know, for their care and all of that. But they're not old enough to own real estate yet. So we wanted our property to go into our trust. And that would be also an automatic transfer to the trust, avoiding probate. And then the trust and the trustee would designate what happens to that property from there. So having a trust, whether you're deeding a property directly into a trust, which depending on your tax situation, you want to make sure you're doing it the right way and the most advantageous way. Sometimes you deed property into a trust, and that also avoids probate. So if I were to deed my property into my trust, just forgetting about any tax issues or property tax issues, then upon my death, whoever I've named as trustee in my trust will handle that real estate and sell it or manage it in the way that the trust document describes. That would also avoid probate because the trust entity will survive me. The trust will survive me. So there's no need for letters of authority or an executor or a personal representative. The trustee will manage that.
Oh, you mentioned executors. I don't think we talked about that. Because let's say there is a situation where it's 5 siblings and there's an executor, what would be their position?
Well, in Michigan, we call the executor the personal representative, and that's
Oh,
just somebody that's handling they're interchangeable. A lot of states call it an executor. In Michigan, we call it a personal representative. So that's just the person with authority to act on the decedent estate.
okay. You already explained what trust and ladybird deed were. So how much would you say it typically costs to set up a trust and ladybird deed in comparison to if you went through the probate process and costs on that?
Sure. So there's many reasons that somebody would want to have a trust, for example, or to avoid probate for real estate. But it's not just for avoiding probate. If somebody wanted to control what happens to their property or their assets or their money after their death, aside from just assigning it to somebody, then they may want a trust. For example, if I have minor children and I wanted I wanted them to receive money over time. Like maybe I want X amount of dollars for them to receive at 18, X amount at 25, X amount at the age 30, or I wanted a specific amount to be used for college or university only, a certain amount for medical expenses, or I wanted to control how long somebody's living in a piece of property that the trust owns or that I own. All those reasons may be handled through a trust, but would not be handled through a will. So an individual that wants to control what happens to their property after their death would want a trust. And when we do estate planning packages, we typically include a trust if that's what they need or that's what they want. And we also have a will, but the will would pour over into the trust. So if anything was missed and not transferred to the trust automatically, or the trust was not funded properly, we would have a will so that anything in the individual's name only at the time of their death be controlled through probate and through the will, but the will would say that everything goes into the trust and consolidates into the trust. For an estate plan package that would include powers of attorney, a will, a trust, that package would typically cost anywhere in this area around $3,000 to $8,000. Going through a probate process, if you only had a will or if you didn't have a will at all, that could cost significantly more or a little bit less depending on the extent and complexity of the estate. So if an estate if the decedent owned multiple businesses, for example, or had very complicated real estate holdings or investments or other types of financial holdings, that needed to be administered, and there was a lot of hands-on work that needed to be done. I've seen some decedent estates that cost tens of thousands of dollars. Sometimes there's litigation in estates that can cause even more. You've probably heard of the Aretha Franklin estate. That lasted years and years and probably cost hundreds of thousands of dollars. A lot of it could have been avoided had she had an estate plan that was clear and locked down and not hidden in a couch cushion. So it's always cost effective to have a plan, meet with an attorney, get an estate plan, determine what you need, rather than trying to leave it to your family to kind of fix everything if maybe you didn't make the proper planning and take that small expense could turn into a larger expense without any proper plan.
Yeah, because since you're talking about different reasons to have a trust, and I don't know if for some reason if I missed it, but just like if you buy a property in your own name versus buying the property already into a trust or an LLC, in some ways that can just protect your property a little bit better, them not fully knowing, okay, you are the owner of the property in case they want to come after you, correct? Or things like that.
Yes. So, let's say you own a piece of rental property. It may not be a good idea for you to own it in your own name. It's not going to be, you're not going to have a principal residency exemption for tax purposes, for example. So, you might want to have that owned by an LLC, which would limit the liability of the owner if there were to be any problems. you know, for example, if there was a lawsuit because somebody slipped and injured themselves on the property, they'd only be able to go after the assets of the LLC because the LLC is the owner of the property. They wouldn't be able to get to the owner of the LLC, the individual person. Their liability would be limited to the LLC. So for rental properties especially, they should not be owned in an individual's name. They should be owned in a limited liability company, or some other type of business that has separate insurance and all that.
And I know not to get too off topic, but just to clarify too, because I've heard some people say that they would prefer to put their properties in a trust, but it seems to me that it sounds more like you have your individual LLCs. And then if you decide that you want to incorporate something together, you would then put those LLCs into one big trust, or no?
Well, it depends. There's a lot of different ways to structure it. A trust could be the owner of an LLC. So the trust could be a member of an LLC, and that's how a property is owned. So, or a trust could own real estate in its own right, whether it's because the creator of the trust, this is what we call a settler, the person who created the trust, passed away, and they own property in their name, and it transferred to the trust through a ladybird deed or something like that. You know, trust can own real estate, and then it's almost like you can think of a trust like a business entity to some extent. It's separate from the individual who created the trust. It's separate from the beneficiaries. So you know, you could limit the liability to the assets of the trust. It may or may not, depending on the details of the situation, be a good idea to do that. But you know, that's why it's important to talk to an attorney and come up with a plan that makes sense for your situation.
Okay. So, and I think you kind of clarified, but in case you want to add anything on here to this, you know, there's a lot who don't set up the trust or ladybird deeds because of costs, or you think it's more so because they really just don't know that it could be the best thing to do?
I think a lot of it is that they don't know that it's the best thing you can do. A ladybird deed by itself, that is not very expensive at all. That should be done by $500 or less for an attorney to prepare a ladybird deed for somebody. Now, ladybird deeds are not always the best route for people that have multiple children. If there's multiple owners of a piece of property, a ladybird deed might not be the best idea. For a lot of people, I would say probably most people that own a home either by themselves or maybe with their spouse, a ladybird deed could be an effective way to transfer real estate and avoid the probate process after you're done. And it's not expensive to set up. The good thing about a ladybird deed is you're not deeding the property right away when you sign it. You're setting up what happens to the property and how it is conveyed after your death. You reserve the right to change your mind. You don't need anybody's permission to change your mind. So if I were to, for example, if I were to prepare a ladybird deed and I deeded my house to myself for my lifetime, coupled with the power to change my mind, all that. But if I did nothing, then it automatically goes to you, Patrice. Then if I did nothing and I pass away, the property automatically transfers to you outside of probate. If I change my mind and I'm, 10 years from now, I'm like, you know what? Patrice and I, we got into a big argument. We no longer get along. So I don't want her to have my house. So I'm going to sell it to, on the open market. I have the ability, because I only create a ladybird deed, to change my mind and do that. Whereas kind of an old fashioned way to do it, and some older estate planning attorneys would do this. They would have pocket deeds. So when they created an estate plan for somebody, they'd have a deed from the individual to, using the same example, from me to you, a quitclaim deed, quitclaim my house from myself to you, Patrice. But that's never recorded. It's just held in a safe deposit box, or held in a safe place. And then upon my death, that deed gets recorded. That could be problematic for many reasons. Number one, it's a transfer that's technically effective when the deed's signed, even though it's not recorded. It could create title problems if it is accidentally recorded or recorded out of order. So that's why a ladybird deed is an effective way to kind of give you the best of both worlds. Gives you the flexibility to change your mind and deed it to somebody else. It's not a transfer automatically. Another thing that we've seen often is a parent will add a child to their deed, to their house. They'll deed the property from themselves to themselves and their son as joint tenants with full rights of survivorship, for example. That's an automatic transfer, an automatic conveyance. It automatically gives ownership rights to the son in this example. But it also prevents the parent from changing their mind and selling the property without their son's permission. If they have it falling out, or the son moves away, or is maybe no longer speaks to the parent, I've seen situations where that parent's kind of stuck, can't sell their house, and they can't sever the joint tenancy with rights of survivorship. So they're stuck in that situation because they didn't get the best advice when they added their son to the deed.
Yeah. And going back to quitclaim deeds, let's say that so this is sometimes that happens where let's say two people, husband and wife, want to be on title, but only one of them qualifies for the mortgage. And depending on the lender, they may not allow the wife or the husband, whoever is the one that's not qualified, to be on the mortgage, which would make it complicated for them to be on the title. They may not allow one, not the other. And so some will say, okay, well, you can quitclaim it to that spouse once you close. But I've been told before that, let's say they got a really nice title policy, they got an Eagle title policy, which is a full title policy. If you quitclaim it, then that would void that title policy out. Is that true?
Maybe. It depends on what the language of the policy says, and it depends again on how the property is deeded. If you're adding a spouse, and so if only one person is on the mortgage, typically the mortgage company will want only one person on title when you write the mortgage. Then that and then they deed it later. If they deed it just to add their spouse, that's not always going to invalidate a policy or trigger a due on sale clause in the mortgage. But that's why it's important, I think, to read the title policy language, read the mortgage language, and all that fine print. It means something, and it can have an effect on what happens if you violate that language and you deed a property to a new owner that you shouldn't. Transferring the property without staying on the property. So if you were to get a mortgage and in your situation, there's a husband and wife, but let's say only the wife qualifies for the mortgage. So the husband is not on title at the time of closing, is not on the mortgage at the time of closing. But then after closing, the wife transfers the property to the husband and just quitclaims it to him outright. That's going to be very problematic. That's going to probably violate the title policy, and the new owner, the husband by himself, is not going to be insured. And it's also probably going to trigger a due on sale clause from the mortgage, meaning that the mortgage company can call the whole note due, the whole amount due. So again, it's important for to consult with an attorney and somebody who knows the ramifications of what happens when you add somebody to you deed it out.
Okay, so we're almost done here. Some people may have an attorney in the family or have used an attorney for something else, such as divorce, and they may want to have this person set things up for them because they know them. Can you explain why it's best they hire a real estate attorney and not just any attorney that doesn't specialize in real estate?
Yes, you would want to hire an attorney that at least one of their main areas of practice is real estate, and they're practicing that area often. Because I see a lot of attorneys that it's not hard to create a quitclaim deed, for example, but knowing the way that you convey it and what the ramifications are is very, very important, because you could deal with if you transfer the property without knowing what you're doing, without kind of planning for it, you could uncap the property taxes. So the property taxes the house could be reassessed and property taxes go way up. That could be unintentional. Or you could add somebody to the deed in a way that's not advantageous. Either somebody who's not well versed in real estate law might not know that they can do a ladybird deed rather than deeding a property to their child or adding their child to a deed directly. And that could be problematic for, depending on how they add that child. So there's also a difference between the way that somebody can own property on a deed. There's tenants in common, there's joint tenants, and there's joint tenants with full rights of survivorship. I've often seen a situation where somebody added, let's say they added a girlfriend or a boyfriend to a piece of property, and they added them as joint tenants with full rights of survivorship. That's okay as long as that couple gets along. And then if one of them were to pass away, the other owns the property in full. Well, because you added that magic language of joint tenants with full rights of survivorship, you can't break it without agreement by both. So what I see probably 3 or 4 times a year, I get a contact by somebody, hey, I just broke up with my girlfriend or my boyfriend. We're both on the deed as joint tenants with full rights of survivorship. I want to sell the house, but my girlfriend doesn't. What can I do? Sorry, man, you're stuck because you had somebody prepare a deed that says joint tenants with full rights of survivorship, meaning you can't just file a lawsuit to force the sale of the property because you're going to need her to agree to it. And because it says joint tenants with full rights of survivorship, you can't break that. You need agreement by both of the owners to sell the property. Now, if they had come to an attorney this happens a lot. People are not married and they buy property together. That's great. That's well, good and fine. But knowing and planning for the unanticipated or maybe the improbable of breaking up in the future, you want to make sure that you do it right. So I would recommend that you add, when that couple comes to me and they say, hey, I just bought a piece of property or I'm buying it together with my girlfriend, I want to add her to the property, add them as joint tenants. Leave off the words with full rights of survivorship. Because if you have it as joint tenants, let's say they break up, then the boyfriend can file a lawsuit to force a sale. And that could go through, and then it would go to auction if they couldn't agree on the sale. But you can force a sale, which you don't want to be in a situation where you're stuck with a piece of real estate because you added somebody to a deed and you didn't do it the right way, and now there's nothing you can do about it. So I think those little nuances are the reasons why it's important to go to somebody that handles these types of matters, practices in these types of areas, and can give you the advice that's good for your situation and doesn't create more problems later. Which unfortunately that's a lot of what we do is cleaning up problems that could have been avoided or were created by either inexperienced individuals or people that got bad legal advice.
Okay. Well, you already answered the last question. Oh, no, sorry. So when specifically would you recommend a client set up their trust or ladybird deed, whether it's to, I guess specifically going towards probate, but if any other scenarios that you can think of, when would be the best time to go ahead and do that?
I think anytime that you're thinking about what's going to happen to my assets, my property after I die, and you want to make sure that your family is provided for and that there's no problems that your family has to clean up, then that's the right time to meet with an attorney, discuss what type of estate plan you need, whether you need a trust, whether you want to transfer your real estate through other mechanisms like a ladybird deed or deeding it to a business or deeding it to a trust or any of those things. A qualified estate planning attorney and a real estate attorney can give you that advice and talk through different scenarios, find the right package that works for you. And I think anytime that you care about your family enough to not have them clean up a mess that you didn't plan for, that's a good time to meet with that attorney and talk about an estate plan and a trust or a ladybird deed. So everybody should have that conversation anytime they own any significant assets or even just a home.
Okay. And anything you want to add?
Just that, a little bit about my firm. We handle a lot of real estate matters. We handle a lot of probate matters, transactional and administration, all the way through complex litigation. We also handle a lot of business litigation matters and create businesses and help people form businesses, whether they're real estate investors or just an average family that wants to make sure that they have a plan in place for what happens when they pass. So, we'd be happy to help, any of your clients or anybody else that would need to have those conversations.
And what is the best way for people to reach out to you?
The best way to reach us is to contact us at 248-939-5405 and set an appointment with an attorney. And they can also reach us through our website, which is theheadlawfirm.com. And they can submit a request for an appointment or a consultation that way. We do give free 30-minute consultations. So, either email or through our website or giving us a call and scheduling an appointment. That's the best way to do it.
All right. Well, I appreciate your time and thank you for the information, and I hope you enjoy the rest of your day.
Thank you very much. Have a great weekend.
Thank you too.
Thank you. Bye-bye.
If you've enjoyed watching this video and would love to stay up to date when I have more content like this or something similar that you may be interested in, please like and subscribe to this channel and click the bell so you get notifications. And I hope you have a great day.